Good afternoon, ladies and gentlemen. I'm Stephen Toole from Avanan, the cloud security platform, and I want to welcome you to today's live web presentation on the Cloud and Cybersecurity Law, a panel discussion on regulation and technology. We have an esteemed panel of experts joining us today to lead the discussion. I'll be moderating the conversation. I'd like to introduce you to our panelists today. First off, we have Chantal Bernier. Chantal is a former privacy regulator in Canada and a partner with Denton's privacy and cybersecurity team. Also from Denton's is Todd Daubert from the Washington, D.C. area, an engineer and legal partner in Denton's D.C. office. And from Avanan today, we have Michael Landewe, who is one of our co-founders, a cloud security expert, and he's going to be providing some insights on the technical aspects today of the cloud and cybersecurity law. So what are our learning objectives for today? Primarily, we want to discuss the legal implications of moving data into the cloud and the technology available to help meet these requirements remain within legal compliance, as well as all ethical standards and sound business practices. Now, we all should be very familiar with the benefits of the cloud and all of the wonderful things that the cloud stand to offer. It's estimated from Cisco that in the next couple of years, 4 out of 5 as a percentage of workloads, 86% will be processed by cloud data centers, leaving just a little less than 15% remaining in traditional data centers, which has huge implications for legal, regulatory, and ethical practices. The promises of the cloud, of course, with cost efficiency. Flip side of that is the risks, loss of control over data usage and security. Big benefit, scalability. Risk that goes associated with that is, of course, loss of data sovereignty. Huge benefit, accessibility. Risk that carries, uneven reliability of the cloud. And last but not least, security can be a double-edged sword, a benefit as well as a risk. And when your information is in the cloud, it's often cloudy, so to speak, exactly whose responsibility and liability the safeguarding of that information quite is. So we're going to be talking a little bit about, to start things off here, the current state of data security regulation and cloud infrastructure. So to begin the conversation, I'd like to just start off that data security requirements are cropping up all around the world with regard to the cloud. In U.S., Europe, and for example, China just introduced new legislation this fall. So to start off the conversation, I'd like to ask Chantal a question. Chantal, thank you for joining us today.
Thank you.
So Chantal, could you please give our audience today a brief overview of some of the recent security legislation and talk a little bit about how this applies to companies that are moving their data to the cloud?
Sure. So first of all, greetings everyone, and we can move to the next slide where we will start with Canada. In fact, the trend that is most relevant to cloud is the fact that more and more countries want to restrict storage of data abroad. And of course, being delocalized, so to speak, cloud is impacted by this legislative movement. As far as since the Patriot Act was adopted, you can see that in Canada, you see from this slide that data residency requirements have cropped up. For example, in British Columbia and in the province of Nova Scotia, public bodies are not allowed to store personal information on cloud except with consent. So obviously, if you are a cloud provider and want to offer services to those public bodies, that is something to take into account, and they would probably either have a mechanism to get consent from users, or they would have you have servers in Canada. If you are a contractor for these governments, there will be a request as to where you store the data and are you using a foreign cloud. In Alberta, the requirement is a little less stringent. All that is required is that the users, the individuals whose information is uploaded to the cloud, are notified. But in general, in Canada, it is highly recommended that they be notified. In Quebec, there's a specific environment equivalency restrictions, meaning you can't store up to the cloud unless you have really ensured that the cloud is reliable. And if we go to the next slide, this gives you a chart of kind of where different states are. So you see Europe on top is the most restrictive. You cannot export, so to be personal data outside of Europe unless very strict conditions are met. And you can see that there are other states that are moving in that direction. You could add to this slide Russia. We all have heard of the dispute between LinkedIn and Russia right now, where LinkedIn was blocked precisely because of the issue of data storage outside of Russia. We could also add Colombia, where they are moving towards the European model, which, as you can see from this chart, is the most restrictive. So that is an overview of the international trend that is impacting cloud, which is the requirement for data storage in the country of origin.
Well, thank you, Chantal. So question for Todd. Todd, how does this change the relationship between customer and the cloud provider?
Well, I think that the ever-changing regulatory environment and the increasing focus on where data is stored and what can be done with it has really overlaid another level of complexity to the process of evaluating whether cloud services are appropriate for you, and if so, sort of allocating responsibilities between a customer and a cloud service provider. And I think what's really critical to understand is, the cloud isn't magic. Depending upon the type of service that you are selecting, whether it's infrastructure as a service or platform as a service or whatever degree of responsibility you want to allocate to the service provider, you still have to have a full understanding of what is happening to your data. Where is it? Where is it being stored? Where is it being transferred, to ensure that you are meeting your obligations, your legal obligations, and that you're able to demonstrate that you've done the due diligence and that you've actually taken the steps necessary to comply. And I think that another new development is the imposition of liability directly on the cloud service providers themselves. So, for example, in Europe with GDPR, for the first time, the processors are directly liable for data that's covered by the Act. So I think that with this new era of regulation, I think that it's no longer sufficient to have a conversation where a cloud service provider says, well, we're a one-to-many service and our security measures are adequate. I think that this is going to require both the customers and the providers to engage in a much more detailed conversation and really work on using technology to ensure that both sides are taking the steps necessary to protect themselves and ensuring that they can demonstrate compliance in the event that something goes wrong. And sort of one last point on this is that you can't lose sight of the fact that of utmost importance is that you don't have a breach in the first place, and that you actually have the types of conversations to ensure that both parties know what the other party is capable of doing, and that your contracts actually match that in a very pragmatic and real way. Because you can't really view compliance as a checklist item where you come up with legal language that looks great on paper, but that nobody's actually capable of following or implementing. That's the worst mistake of all. So I guess, the advice would be do the right thing, protect the data, and then make sure that you've done it in a way that complies with the actual technical requirements.
Thank you, Todd. Now, there's a couple of questions coming in from the audience. I'd like to pause for a moment and chime those in. Michael from our audience has a question about actually the current slide. Michael's question is, the chart shows that there are no data residency requirements for the U.S., but aren't there data residency requirements for government, banking, and other regulated industries?
This is Todd. I'll take that one. Yeah, there is. There's not the general country-wide, region-wide restrictions that apply to everyone. But it's a really great point because there are numerous sources of privacy and data security requirements for the U.S. For example, there's well over 50 statutes alone that that apply various different requirements depending upon the type of data involved and the type of customers. And that's not to mention government policies. So even if there's not a statute that directly impacts what you're doing, if you want to have government customers, or if you're going to be storing unclassified but covered information from the government, you have to take certain steps to comply with certain NIST standards and other even agency-specific standards. So it is a really great point, and I think that just for the high level of detail that we've shown, it's just that we as a country have not adopted a nationwide policy that data must be stored in the U.S. unless there are certain protections in place.
Well, thanks, Todd. And there's a couple of questions regarding Chantal's information, her answer previously. One's from Megan, and her question is, for the slide about Canada, does this only apply to public bodies? And Robert had a similar question. His question is, regarding Canada, is cloud PII storage restrictions specific to public cloud or private community cloud as well, or to cloud storage outside of Canada? Chantal?
So the restriction is upon public bodies only, but it impacts the private sector in the sense that obviously when either a private contractor is working for the government and will hold the personal data for the government on a cloud, then that will be an issue, and those two provinces will ask, where do you store the data? So that's the first point. It's public bodies only, even in these provinces. The requirement that you notify, that's broadly private sector as well, because it is seen as a matter of transparency, that you should let your users know that their information could be held outside of Canada. With respect to whether it applies to public cloud or private cloud, the legislation is formulated in terms of no storage or access abroad. So that is the standard. It is not specifically to a type of cloud or to even to cloud. It is specifically to the issue of extraterritorial storage of data.
Very good. So with all this regulation in the U.S. and Canada and other countries, Michael, could you please share with us what are some of the technology measures and capabilities, infrastructure that companies have at their disposal to manage and remain within all of these requirements?
Thanks, Stephen. So Todd described the cloud, or at least the way it was imagined a decade ago, as being a mysterious black box in which you might put your data or do your processing. And we once had very little visibility into what was going on in the cloud. And when corporations defined their network perimeter, the cloud was considered to be outside this perimeter. It was considered the other. And so confidential data had to be maintained inside their corporate network, and the cloud was considered outside. In fact, it's this old model, which is why some organizations have been hesitant to trust their data there. Now, here's a diagram I like to use to put the technology in perspective, kind of dig into that black box. Today, the cloud has become so-called enterprise ready. It provides the visibility and the control at each of the physical layers to meet the compliance requirements. And so at the lower layers, and that is, where is the data physically stored? How is it being stored? All the way up to the application layer, and then to the data and the user layer. We can see that with new technologies, new API visibility, corporations can actually get some visibility into those lower layers. So they know where the data is being stored. They know how it's being managed at the lower layers. And then more importantly, those same APIs give corporations visibility and then even additional controls at the higher layers over managing the data, managing the people. So in the end, the cloud can now be a part of the corporate IT, and that perimeter now includes their data that's in the cloud.
Very good, Michael. And another question just came in from our audience. This is from Donald, and this is sort of related to technology as well as borders. Donald's question is, let's see, I'm going to try to paraphrase it a little bit here, that he understands there's concern from personal data privacy perspective, but what about concerns about the sensitivity of technological data? So if the cloud is cross-border, couldn't there be export control concerns if the data is of a sensitive or technological manner, and wouldn't this limit R&D tech firms from availing themselves of cloud providers? Very long question, but I think I summarized it succinctly. Perhaps our panelists could address that question for Donald.
I might be able to answer that in that this is a case in which the cloud providers are starting to grant their customers that visibility into the lower layers and actually making decisions about those lower layers, so that part of the agreement may be that data in one location is held in a different way than in another location, because in the end the cloud is a physical place, a physical infrastructure, and granting more control to the IT gives you that compliance enforcement ability.
Yeah, this is Todd. I want to follow up on what Michael said. I think it's a great point, and it's a great question, because as an engineer, when I hear people talk about the cloud sometimes, it seems like they forget that this is actually real networks, real servers, real places. And I think that your question is a really good one. When you put data into a cloud service, not all data is the same. And the same laws that apply to you when you're using your own internal corporate networks continue to apply if you're using cloud services, which is critical, which shows exactly why you have to really plan and think about the types of data that you have, any restrictions to which that data is subject, and then to match up the cloud services that you're considering to ensure that they allow you the granularity of control you need so that you can determine where your data is stored and processed, and can demonstrate that your use of this cloud service has not caused you to violate these other requirements, or OFAC, or export-import, or service or subject matter specific requirements like healthcare or government information. So it's a great question.
I will just add, indeed, that I understand the question to really go also at data that can be sensitive from a national security point of view. And in Canada, the Industry Security Program does indeed request some security levels for those data exports, and in the U.S., the Defense Security Service also has, as a counterpart, has the screening and all of the regulations as to what can be shared abroad or shared at all. So yes, definitely there are specific standards, as Todd says, for that type of sensitive information.
Very good. Good discussion. So let's keep moving. Talk a little bit about data control and the different shades of sensitivity of data. So current requirements mandate that information has to be protected at a level that's commensurate with its sensitivity, which could mean varying levels of safeguards. So Chantal, we'll stay with you. What do companies need to consider when moving their data to the cloud? How do they analyze the requirements?
So if we move to the next slide, you will see a list of sort of to-do that I developed with a group of chief information officers from organizations that have very sensitive information, and therefore where the idea of going on cloud was causing a lot of concern, and yet it was obviously an efficient solution. So what you see here is what this group of CIOs came up with as to how they bring their organizations on cloud successfully. So the first of all is to need the best use of cloud for that organization. They said not all organizations benefit from cloud because they don't need, for example, as you were mentioning earlier, Stephen, the scalability. They don't need that. And so the first question a corporation or an organization needs to ask itself is whether there is really an advantage for it. Then, as you were mentioning earlier, analyze the risks and benefits. Can you afford a truly reliable cloud, or can you afford to keep your information within your infrastructure, and you can afford to actually have an infrastructure that is at the level of protection that is required? So that's the second step. And then understand the legal obligations relating to cloud. So the whole conversation we've just had about data residency, this is very important. So if you go on a cloud that does not have servers in your country and it is an issue in your type of business, that's something you should know to make sure that you get a cloud that has servers in your country if indeed data residency requirements apply to you. So once you've decided to go on cloud, look, this is the focus on, and it goes a lot to what Todd was saying earlier on, meaning make sure that you have strong contractual clauses. The cloud provider is subordinate to you. It's your data, and therefore make sure it will never use it in another manner that you have undertaken to use it. Also, don't be shy to impose compliance provisions such as audits and being immediately notified if there is a breach. The other issue is once you terminate the relationship, make sure they return or dispose of the data. You also have to make sure that they have business continuity in case they have an issue so that you are not left in the arc. And then you also have to make sure that they have their own capacity to secure the data. Finally, make sure that they can integrate your directory services. So you will have data that is less sensitive, more sensitive, extra sensitive. Well, make sure that they too can compartmentalize it that way to respect your distinctions. And finally, one thing they mentioned is make sure you go with a financially stable cloud so that it doesn't disappear on you and put your data at risk.
Well, that's an awful lot to keep track of. Chantal, thank you for that really insightful overview there. So turning it over to Todd. Todd, is the cloud provider really responsible for all this? What are they responsible for, and what falls on the shoulders of the company, the customer, in terms of shared risk and responsibility? Todd, could you touch on that for a minute?
Yeah, I think that what a lot of us have been mentioning is that it's of critical importance, first of all, to sort of do your own homework about your needs and your obligations before you even start looking at any cloud-based services. Then you can decide what type of cloud-based services might be appropriate. You know, infrastructure as a service is really different from software as a service, and depending upon your particular needs, it may become clear that one is a better use to you than the others. And then it's time, really, when you start negotiating with the cloud service provider, that you have these really pragmatic discussions about what you need and about what their capabilities really are, and trying to make sure that that they're really able to do what you're asking them to do. Because if they aren't, then you want to get a different provider. And I sort of view this as negotiating a prenup in a way, you need to get to know your future spouse and know what they can do and what they can't do. And this is the time when you get along the best. So if you can't talk about potential troubles now, then you're never really going to have a good relationship. And you just need to be able to document it all, because the people who talk about these at the beginning may not be the same people who have to implement it on a going forward basis. So this really requires teamwork from your IT, your engineers, your legal, to make sure that you're doing the right thing and that you captured it in contractual language that was written for the real world, not just the legal scholars. And I just can't stress enough the importance of really understanding what it means when you put some obligation into a contract. And so, as that conversation goes along, you can identify with specificity who is responsible for what actions, and that will help you ensure that you're meeting your obligations under the law. The law places the obligation on certain parties, and while you can transfer risk in that you can require indemnification or insurance or other measures to make you whole, you can't typically shift your first level obligation under the law to take certain actions. So you just also need to make sure that your contracts reflect a healthy understanding of what those obligations are.
Gotcha. Prenup. I like the sounds of that. Before I ask Michael to chime in on the technology side, I want to get to a question from one of our audience members. By the way, you've been a great audience. We've got several hundred people live on the audience today, so I appreciate everybody's participation. It's been a very great conversation so far. So Abdullah from our audience has a question, and I think the question, this could be a topic for a whole separate webinar, so we have to try to curtail our responses to keep within the time limits. But Abdullah is thinking ahead. He wants to know, well, how do you respond when there's a security breach? Intercontinental, inter-providence companies.
You mean go ahead, Todd.
Well, I think that provides yet another example of what we're talking about, because there are different legal obligations that apply to parties when a breach happens. And sometimes they're seemingly inconsistent. So, for example, you have requirements in most of the states in the U.S. that either require you to provide notice within a certain period of time, or that require you not to say anything about it because they don't want to tip off criminals in the event of an investigation. You also have other requirements. For example, if you're talking about customer proprietary network information for telecommunication services, there are very specific requirements about who you can tell, the fact that you need to report it to the Secret Service and FBI so that they can take action. And so what you must do is you must plan ahead and have a playbook ready to go before a breach happens, because we all know that suspected breaches or breaches are likely to happen at some point, even if you've done a great job. And you can't be scrambling under those pressure situations to try to identify your obligation if you've never thought about them. And so if you have your playbook and you know what you need to do when you are negotiating with your cloud service provider, it becomes enormously easier to make sure that their notification requirements to you line up with your plan, and that you have the ability to adjust that as necessary as the laws change. And you also need to make sure that they can actually meet those standards, and that they're not promising the moon and stars just because they want to get the contract.
So a couple of questions just rolled in from the audience, I think, that are appropriate. One's from Stephen and the other's from Jana. And they both want to know how practical it is to go to an AWS, Azure, SAP, or Oracle and say, here are our terms, and they just want to say, hey, check our box, take it or leave it, in terms of their licensing agreements, if you will. I've paraphrased their questions, but I hope I've encapsulated what they're looking for there.
Well, I will put this to them. There is now an ISO standard 27018, and there are ISO standards 27001 that actually define the obligations of data security on cloud. And so if you go with a cloud that is certified under these ISO standards, you will have clouds that comply with a framework that is fair to the customer.
Thank you, Chantal.
And this is Todd. If I can join in on this, I think it's a fantastic question, and I think that in the past you used to see people say, "Well, I'm a one-to-many, so my terms rule because I can't change them." I think that a lot of the providers have become much more sophisticated, and so that this flexibility and the ability to solve the problems for their customers is worked into a lot of the terms. But the bottom line is your ability to change terms really hinges on two things. One is, how important are you to the service provider? If you're a little fish in their giant sea, the chances that you're going to make major changes are just much diminished. It's a fact of life. Whereas if you're a major contract that they really want, the chances that you'll be able to get things to change are much higher. But that said, given the way cloud services are provided, you don't want to insist on language changes that are inconsistent with the way they do things, because the most important thing is that they actually are following procedures that they're capable of following. And if you force someone to do too many one-off things, you actually create the risk that they won't even comply with their own procedures, and you could cause problems for actually protecting your data. So I think you have to take a sophisticated view of this and go in and really listen and have in-depth discussions about what their language is and why they say it in a certain way, and whether there are options for other treatment which are frequently available, but they don't talk about unless you ask about them specifically.
Very good. Thank you, Todd. So, Michael, turning to you, these agreements that we've been talking about for the last few minutes have defined who owns different types of risk. So obviously you can't just shift all of that risk to your cloud provider. Nobody's going to agree to that. Michael, so the risk that you're left holding as the company, what can you do to mitigate that risk? What are some of the technology advancements that are available to absorb, offset, and mitigate the risk that you're left with holding after you sign those agreements?
Absolutely. And so I think what I like to do is look at it from the technology side to kind of put into context the agreements we've been talking about so far. And in fact, if you go to any cloud provider and talk about what's called the shared responsibility model for cloud security, actually cloud compliance and so on, it really depends on the type of cloud you're talking about. So if you're using a service like Amazon or Azure, infrastructure as a service, then by definition, you're responsible for so much more. So Amazon obviously is going to be responsible for the physical network and the physical servers and so on. And you obviously are going to be responsible for your users and the applications you're running there. And where you're negotiating is at that layer, and it might move up and it might move down, but that's the place for negotiation. So if you go to Amazon and say, I want you to be 100% responsible for the security of my applications, you're asking for something that's outside the scope. However, if you are offering platform as a service or you're going to a SaaS provider, then the line moves up. So of course the SaaS provider is going to be 100% responsible to lower layers, but at that line is where you start negotiating. And so, for example, no SaaS provider will be 100% responsible for what your users do. If they log in with credentials and do bad things with that data, share, that's outside the scope. You negotiate at that boundary.
Very good. So if we move forward and talk a little bit more about due diligence and compliance, there's a recurring theme in data security, and that is, as I'm sure many of our audience members will agree, if you go to the next slide, is that people are the weakest link. So to address that, there are laws that require certain access controls on the basis of operational need or need to know, and internal compliance measures. So Chantal, assuming that accidents will happen, people will inadvertently do things they shouldn't do, what have you, what is a company's responsibility when it comes to implementing those best effort measures to control data security and privacy?
So if we look at the next slide, the title is really the starting point, meaning that whenever you choose to put your data on cloud, every single one of your responsibilities for that data still remains with you. So you really have to do your due diligence, because once you've put it on cloud and the cloud makes a mistake, let's say, well, you are still on the hook. So you need to remember that. Therefore, be very careful on how you choose your cloud, and demonstrate, actually document your due diligence so you can show accountability. If you're the cloud provider, well, then you are responsible for fulfilling all of the security obligations of the cloud customer. In other words, if the cloud customer is in a country where those are the requirements on protecting this or that type of data, well, those obligations are now shifted to you through contract, and you must live up to those. You have to have your own internal compliance mechanisms to make sure that that is fulfilled. And the last point I will make, because it's tricky and it's so much in the news, particularly now with Microsoft having challenged successfully so far the U.S. government, who wants to have access to data that Microsoft holds in its servers in Ireland. And the United States government says that because Microsoft is a U.S. company, even though the data is in Ireland, it should have access to it for criminal investigation reasons. And Microsoft has been successful in having the court say no. When the data is abroad, it is outside of the jurisdiction of the law enforcement authorities. That being said, it is important to have in your cloud contracts that the cloud provider will reject law enforcement or any other third-party access to the data that you have transferred to it, unless they are with a warrant or at least also consulting you. That is the ideal.
Very good. So Todd, where does a company's responsibility start and stop when it's shared by a cloud provider?
Well, I won't spend too much time talking about this because I think that we've covered it pretty well. I think that, the law is pretty clear about, who is responsible from an enforcer standpoint, whether it's a controller or a processor or both. But I think that the important point is that you need to view this from a rational standpoint, pragmatic standpoint, that the best way to ensure compliance is not to have a breach to begin with. So make sure that you're doing the right things, and then make sure that your contract reflects accurately the obligations that have been assigned to each of the parties, and also permits the parties to document the steps that they've done. Because another thing that I've seen with a lot of companies is they actually do a pretty good job of taking the steps they need to take to protect data, but they don't document it very well. And they don't have good procedures around showing that they've been audited, how they've been audited, showing reporting, showing what steps they've taken to protect the data, so that when something goes wrong and somebody comes in to investigate, as we all know, hindsight is 20/20, they don't have as many documents and materials to show that they actually were taking reasonable steps. So I think it goes back to the point that we've all been making, that when you get into these contracts, if you've thought about it from a logical, pragmatic way, and you ensure that your contract allocates the responsibilities and has the tools that you need to get the types of audits and the reports, that's just critical.
So speaking of tools, Michael, can you talk about some of the technology solutions that are available for both access control and compliance assurance?
Absolutely. And I think Todd's answer in the best solution is to prevent the breach in the first place kind of leads to the importance of integrating the cloud into the existing IT infrastructure, so it actually becomes a part of your overall strategy. Because really the answer is policy automation, so not trusting the human in the loop, so that all of these rules enforcement not only being audited in real time, but also enforced in real time. And what's nice about the cloud and the ability to integrate is that you can automate it in a way that is more realistic. And I think maybe as an example, a financial firm that might be subject to SEC regulations when it comes to data control, there might be the users of the data, if it's in the cloud, might be the public, it might be a partner firm, their customer, or even an investor on one side of a regulatory wall and then a banker on the other. So all those different types of users can be defined by connecting it to their user infrastructure, permissions infrastructure. But then, even though they're all sharing their data via a single cloud provider like Box or OneDrive or something, they can't use the existing permission tools to control the data to that level, but by integrating with their existing user directory and using the same data classification tools that they might already have, if an employee uploads a confidential file, the location, the encryption, the permissions can be applied automatically. And while it will always be important to educate users on policy, it's actually more powerful to either automate the response or interact with the user at that instance. So when they are about to violate a policy, having the software ask if they're sure they want to do that, so that this way you make the tools that they're using for collaboration and sharing a part of the IT infrastructure so that the policy is overlaid upon those tools.
So Michael, given that we've got folks on the call here from many different countries, one of our audience members, Stephen, wants to know about the technology solutions that are available outside of the U.S. His question is, does Avanan have service offerings in the EU or Canadian data centers, e.g. outside of the purview of the Patriot Act?
Yes, so this is a case in which a provider like us or one of our security partners can move the software, the solution that you're looking for, around to different jurisdictions in a way that it can apply to the law that applies to you.
So let's move into malware and cyber attacks, just to keep things going, because we are running a little bit short on time. There's been a lot of news in the past year about malware and cyber attacks, ransomware, phishing scams, those types of things. So let's go back to Chantal. Chantal, so as these types of attacks become more and more sophisticated, what importance do regulators give to due diligence in assessing the accountability, and what are the technological measures that constitute a minimum of due diligence?
So if we go to the next slide, what you have there is a summary of a resolution that was adopted by the regulators, the privacy regulators, on going on cloud, what their expectations were. If I summarized in one sentence, my answer to your question is that the regulators are more and more cognizant of the level of sophistication of attacks, and therefore the test is no longer whether there has been a breach or not. The test is whether there has been due diligence or not. And so we're much more into cyber resilience than cybersecurity, understanding what the actual situation is. Still, if you go through this list here, this gives you an idea of what the regulators want you to do. So first of all, if you hold personal data on cloud, they want you to do a privacy impact assessment. Are you putting that personal information at risk? Including a threat and risk assessment, which applies to personal or other sensitive information, which can be, as we've mentioned before in reply to one of the questions, it can be sensitive government information. Then triage that information. Maybe all can go on cloud, maybe some should not, depending on what is the best protection for that. You will also see on the fourth bullet, it says favor domestic clouds, which is interesting and truly buttresses the first point we've made of that trend towards prohibiting data storage. This does not prohibit data storage, but clearly the regulators would like you to keep the data within the legislative jurisdiction where you have collected it, so that it is protected according to the laws of the country where you have collected it. And so if you look at the bottom, again, require audits, which is something we've mentioned before under compliance. Then if we move to the next slide, then you will see what they want on actual security. And I would love to hear, for example, Michael and Todd on this. So they say, you know, these are all security measures. So I will leave it at that for now and actually turn it to the techies, so to speak, Todd being both an engineer and a lawyer, and to Michael being the technologist here, as to their comments on these specific expectations of the regulators on security.
Yeah, great idea, Chantal. So Todd, why don't you build on that? Can this be codified in the SLAs with the cloud vendors? And what is the customer's responsibility versus the cloud vendor?
Yeah, you know, I think that those two slides are really helpful because they sort of show the views that regulators take of technology, which in many cases actually, as an engineer, I don't share. I don't view clouds as overall a good or a bad thing, and I don't view them necessarily as being riskier or less risky. And so, you know, when I see things like, you know, make sure that the data is stored domestically, there may be reasons for that, but I think that you have to know the way the regulators look at it, and you have to keep that in mind when you do your assessment. And I think that the most important thing that you do is that you engage in sort of a risk-based analysis where you gauge the true magnitude of risk and the nature of the risk that you face, and you adopt the measures that are best going to address those risks. And I'd say that it's not always obvious. You know, we like to think about the Chinese military and the Russian military engaging in sophisticated hacking things. Well, I'll tell you, a lot of times it's an innocent employee, or it's a mistake, or it's somebody using social engineering to get access to something that they really shouldn't have. So I think that if you engage in that type of analysis, maybe following the NIST framework, which is a voluntary framework that is very helpful to companies, and really analyze what you need and what you have. And then when you go to the cloud service provider, you can see, you have to have the conversation with them to see what risks they face and how that coincides both with the risks that you face and with the regulators' expectations. And so I think, you know, I know we're running short on time. This is a whole other topic, but I'll turn it over to Michael to see, you know, what he has to say.
Yeah, so Michael, how does a company meet its due diligence obligation if it's not provided by the cloud vendor?
So I think this is probably a good time to put things in perspective, in that every year Verizon does an analysis of all the major security breaches that took place in the previous year. And 94% of successful breaches, data breaches in 2016, took place at the higher layers. Anytime there was cloud involved, they took place at the higher layer. And for example, stolen credentials, or phishing attacks, those things that are actually going after the greatest weakness, and that is the people. And this actually represents two things. One, the cloud providers are actually doing a very good job. If you were just to do a report card for breaches over the last few years, the attacks are not happening at the physical network. They're not happening even at the application layer when it comes to most cloud providers. Attackers are not going there, one, because it's very, very hard. It's getting harder all the time. And cloud providers have an economy of scale when it comes to response time, staffing. Microsoft alone spends $1 billion on security. The reason why we're seeing breaches at the higher layers is cloud providers are doing a good job, and then the weakest link is our people. And so this leads to those layers of responsibility that actually to most IT people are very, very familiar. These are the security layers that they've already deployed within their own data centers. And what's happening now is the realization that those same security layers are necessary even if the data is in the cloud, because those security layers apply to the people. So like the insider threat problem, or fooling someone with a phishing attack, or the loss of credentials, or malware, data leakage, all of those are the things that, one, are still the responsibility of the customer, but more importantly, are already familiar, already known, already they're already using trusted tools within their data center. And I think this is actually why we exist as a company, because it's our job to allow IT to provide those layers of security on their data and on their people in the cloud. So just a little bit of background for people that don't know us as a company. We've partnered with over 70 of the major security companies like the Symantec's and the McAfee's and those companies that are already being used in the data center to apply those tools in the cloud. And I think that's where the technology comes in. Once you have defined the gaps and where your responsibility leaves off and the cloud provider starts, we come in to provide that technology solution to fill those gaps.
Gotcha. So one last topic before we open it up to Q&A, if there's time remaining. Ransomware seems to be an ever-growing threat. We saw just in the news last month that a entire county government system in the Midwest was shut down for the entire day due to a mass ransomware attack, typically brought on through a phishing scam, which installs malware onto a user's computer and shuts it down until they pay the fine, or the fee, if you will. So as companies and organizations are more and more confronted with ransomware, there seem to be two schools of thoughts on whether or not to pay it. The former suggesting it's a matter of fulfilling safeguarding obligations to pay. So Chantal, what are regulatory policies doing to address this type of threat?
So if you go to the next slide, the regulations do not specifically address that. What the regulations are requiring is to make sure that any information that is entrusted with either a cloud customer for his clients or a cloud provider from his cloud customers be protected at the level that the commitment is made. And so you're right that there are these two schools of thoughts, but if you look at on this slide and you see a suggestion from a former enforcement agent, and the reason I put that in was because in one of those debates that I was at where we were debating this, I found that he really had the best solution, and it was echoed by many, many others, and that is that there is no one rule, and no company should have one fast rule, either pay or not pay. That for every incident, and let's hope it doesn't happen, for any time though that it does happen, look at what is captured. Is it the crown jewels? Is it the critical information, or is it expendable information? And if it is the crown jewels, well then you have to look at, well, how strong were the safeguards that we're defeated? In other words, like, is this truly very difficult to overcome, or can we patch it up? Can we actually correct it ourselves? And then ask yourself, what is most costly, paying up or losing the data? And for each, I would add at this, in this measurement of risk, how do you best honor the trust of those who gave you the information to hold for them? So it's really, I believe, a risk assessment each time based on cost of paying the ransom versus cost of loss of data.
Got it. So Todd, what should companies do to reduce their liability ahead of such a threat, and what are some of the tools that they can use?
Well, we don't have much time, so I'll just keep it at a very high level. Just like planning for a breach, planning for a situation like this is absolutely critical, because when you get a threat like this, you have to make a number of critical decisions, and you don't want to have to do that under pressure. For example, you might think that the best thing to do is to take down your network, but that might not be the right thing. That may actually make the problem worse. So it pays to think about this in advance, to create a policy, a flexible policy, but one that helps you think about the critical factors and have at least a decision plan for how you'll make decisions when you're under pressure. And then you have to make sure that your cloud provider is sort of integrated and that, is consistent with your plan. And your cloud provider could be a great backup plan for you, so that if local data has been compromised, then you know that you've got data recoverable from the cloud. So plan ahead.
And so, Michael, you deal with a lot of companies, customers of Avanan, using the cloud security platform to protect against threats such as ransomware. So the companies you've talked to, Michael, what has been the industry response to the ransomware threat, especially when it comes to the cloud?
So a couple answers there. One is, in analysis of ransomware attacks over the last couple of years, there was a high correlation with those companies that used the cloud were less likely to pay the ransom because the cloud offered the benefits of redundancy and backup and so on, so that the risk was lower just by having their data in the cloud in the first place. But I think more importantly, and this is where the multiple security layers apply, and that is malware and hackers represent an ever-changing threat. And here, the responsibility is not to just set and forget so much as responding to the attacks with multiple layers of defense. So having, for example, signature-based malware detection, or malware sandboxing, or the new next-generation AI malware detection or anomaly detection, looking for that insider threat. And so there's no one company that can be best at all things. So the idea is to choose the technology that best solves that one layer, and that might be one company or 10 companies, 3 companies, but the idea is that it's now possible to choose the technology that best meets that requirement.
Well, thank you, Michael. And we are right at the top of the hour here. I want to be respectful for everyone's time. I know that some of our panelists have other obligations that they need to get off to this afternoon. I want to take a minute to thank Chantal for joining us and for her incredible expertise. Thank you, Chantal. Todd, thank you for joining us. And, of course, Michael as well. For more information, please feel free to visit either dentons.com or avanan.com if you'd like to get to know either of our companies or both in greater detail. So I want to thank everybody again for joining us and wish everybody a very pleasant afternoon. Have a good day, everyone. Thank you.